Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Well, one bad apple can really make the whole barrel look bad. And I think when we look at attorney Michael Avenatti, we realize that the he makes the entire profession of lawyers look bad, but especially those who are plaintiffs' lawyers, because Avenatti was all about the money. And he was all about the money in a disastrously bad way. He couldn't make it faster than he could spend it. He could spend it a lot faster than he made it. And he wound up being convicted of stealing from clients. And, for example, Stormy Daniels, the woman that he represented, he stole from her. And in some cases, what he did was even beyond just the theft and the abuse of clients, he worked very hard to enrich himself, and he didn't care who was hurt in the process. One of the things that Avenatti was convicted for was a bribery/extortion scheme that he perpetrated against Nike. But a lot of what was not understood about that at the beginning of all the publicity that came out about that was that he had leveraged a client's claim, a legitimate claim, by the way, in order to enrich himself. And that is a breach of fiduciary duty. Lawyers have a duty to represent their client zealously within the bounds of the law. And they have to put the client's interests first because they're a fiduciary. And as you'll see in this case coming up, that is not what Michael Avenatti did. So there's this fellow by the name of Franklin. He is a coach. He has a little basketball league out in California. He has groomed some really fabulous basketball players, some of whom went on to play college and pro basketball. And in that role, he got some support from Nike. While he was getting that support from Nike, two employees from Nike decided that they wanted him to pay certain individuals to wear their products, which is corrupt and unlawful. And he didn't want to do it, but he did it in order to preserve the relationship with Nike. And then at some point, Nike just dropped him, and he believed it was due to his complaints to these two people who wanted him to pay these bribes, and he didn't want to do it. So he went and talked to an entertainment consultant by the name of Auerbach, and Auerbach referred him to Avenatti. So we're going to take a look at the case now, and we're going to do it in summary fashion. I'm not going to spend a lot of time going through the whole thing, but I am going to pick out the parts that I think are highly relevant so that you can see exactly what happened. And this is a case from the Second Circuit. So let's take a look at it, and then when I'm finished with that, I'll come back and have a couple of additional comments. This is the opinion from the United States Court of Appeals for the Second Circuit in their August term. It's Avenatti versus the United States. One of the things they begin with is, because none of these challenges has merit, we affirm the judgment of conviction. And in affirming the judgment of conviction, they spill a lot of ink in affirming this conviction if it has no merit. Instead of simply asserting that it has no merit and dealing with it in summary fashion, they go to a great length here to make a record and point out exactly how bad the conduct really was. We're not going to go into all of it. As I mentioned, Gary Franklin was the basketball coach, and guys by the name of Jamal James and Carlton DeBose were the people at Nike who were alleged to have asked him to make payments with false invoices. So Franklin went to a guy by the name of Jeffrey Auerbach, an entertainment industry consultant, and his son had played for Franklin on his Cal Supreme team. So they talked about it, and they decided they would approach Nike with it because he knew one of the executives at Nike. And the executive said, don't want to hear anything about it, talk to our lawyers. So they decided that if Nike needed a lawyer, they needed a lawyer too. And unfortunately, Auerbach, on Franklin's behalf, contacted Michael Avenatti. Auerbach and Franklin detailed that justice for Franklin met these 5 goals. First, he wanted to reestablish a sponsorship relationship with Nike. He wanted to resume coaching his former team. He wanted to have James and DuBose fired. He wanted to receive whistleblower protection. And finally, to be paid some sort of compensation by Nike. And he emphasized that maintaining a relationship with Nike was most important to him. Now, neither he nor Franklin nor Avenatti mentioned the possibility of a public disclosure of any internal investigation of Nike. The court then points out that Avenatti was having financial difficulties. He had been kicked out of his law offices. He had $11 million in debt. So Avenatti has some initial discussions with Nike, and he calls his pal Mark Garagos and says, hey, you know somebody at Nike, maybe I could get you to open the door for me and we could have a conversation with him. So they essentially have this conversation, and Avenatti told Franklin that after that meeting, he expected to get Franklin some sort of immunity from prosecution and $1 million in compensation. But he made no mention of his plans to demand an internal investigation retainer or make public Franklin's story. He told Nike representatives, they say he adopted an aggressive and bullying tone, pay a civil settlement for breach of contract, tort, or other claims, and hire me and Garagos to conduct an internal investigation into corruption in basketball. So he was leveraging Franklin's information, and he had lots of documentation about these payments. He was going to leverage that information against Nike in order to get Nike to hire him. Now, the first big problem with that is if you represent Franklin against Nike, you can't represent Nike at the same time in an internal investigation. Now, Avenatti testified at trial that he was going to do this in series. He was going to get Franklin his money, and then he was going to conduct the investigation. Except pretty much everything about the investigation appeared to be a shakedown. And Avenatti told Nike's representatives that if his 2 demands weren't met, he was going to blow the lid on the scandal. In other words, he was going to go to the media, he was going to disclose all of these payments, and he was going to cause Nike to have the same kind of headache that Adidas has had when Adidas had done this with some of their customers and some of their payments. Using forbearance, Wilson, the lawyer from the law firm that represented the good people at Nike, he said, look, you can't do that because a public scandal would destroy the life or destroy the careers of some of these kids whose parents or handlers receive payments. And Avenatti shouted, I don't give a darn about those kids. He said the delay would mess him and Garagos over, and he made no mention of any effect on his client Franklin. After the meeting, Avenatti spoke with Franklin and told him that things went well and that there'd be another meeting on March 21st. Meanwhile, a few hours after the meeting, Wilson contacted federal prosecutors in New York, disclosed what happened, and agreed to cooperate in an investigation of Avenatti and Garagos. As a result of their subsequent conversations, Avenatti and or Garagos were recorded in their calls with Nike. So on the March 20, 2019 call, Wilson told him that Nike was not going to give you everything you want, but I think we can give you much of what we want. And Avenatti responded by reiterating his 2 demands, saying, look, we're going to get $1.5 million for our guy, and we're going to handle the internal investigation. And if you don't want to do that, we're done. And he said, you know, a few $1 million, it's worth more in me and exposure just to blow the lid on this thing. So if Nike were thinking a retainer could be capped at $3 or $5 or $7 million, let's just be done. Avenatti reiterated several times that he wasn't thinking about a single-digit millions, in other words, $5, $6, $7, $8 million. He said that's not in the ballpark. So Wilson said something to the effect of, well, you know, I suppose an investigation like this could run between $10 and $20 million, and Avenatti characterized that as within the degree of reasonableness. So they agreed to another meeting the next day, and at the March 21 meeting, Wilson, Holmes, Avenatti, and Garagos in fact met, and they started with what he characterized as the easy part. Avenatti handed Wilson a draft settlement agreement among Nike, Franklin, and Cal Supreme, which obligated Nike to pay $1.5 million in return for a general release of all claims. One thing that Avenatti didn't do, or I should say he did this almost immediately after getting into these negotiations, was throw Franklin under the bus and say, no, we're not going to ask that you put him back on Cal Supreme or reestablish a relationship with him. We're just not going to do that. We're going to get him $1.5 million and we'll be done. So Avenatti proposed that his demand for a investigation be put in a separate confidential retainer agreement where they agreed to pay a $12 million retainer on signing, and it was deemed earned when paid, which is categorically unlawful. You can't do that if you haven't actually done work. And he said the agreement would be capped at $25 million, but would have to guarantee at least $15 million. In response to Wilson's inquiry, he said that Avenatti stated it was payments made to players in order to route them to various colleges or shoe contracts prior to them being eligible to receive any such payments. And as to the billing rates, that was supposed to be the subject of the investigation. As to his billing rates, Avenatti proposed blended hourly rates of $950 for attorneys and $450 for paralegals. And, of course, reimbursement of all out-of-pocket expenses. When Wilson observed that he'd never received $12 million from any client as a retainer for an investigation, Avenatti was dismissive, and he said, have you ever held the private parts of a client in your hand where you can take $5-6 billion in market cap off of them? Avenatti stated that when compared to the damage he could cause Nike, his $25 million demand was not a lot of money in the grand scheme of things. One of the things that you should notice here is that we started at $12 million and now we're at a $25 million demand. That's pretty funny, and it basically betrays his expectation that it would reach that $25 million cap. But he did assure them that, look, if you pay my demands, I'm going to maintain strict confidentiality. So later in the meeting, Avenatti stated that if Nike wants to have one confidential settlement agreement and we're done, then they can buy that for $22.5 million, a number that he described as magical. And basically that was $1.5 million for the client and $21 million for he and Garagos. Warning Wilson not to underestimate how badly he could hurt Nike if we don't reach a resolution, Avenatti stated that once he held a press conference, this is going to snowball. Parents, coaches, friends, all kinds of people are going to contact him. In a telephone call on March 21, Avenatti assured Franklin and Auerbach that things were going well, but he made no mention of the two options he gave Nike. Then later in the day, he tweeted an article about the Adidas scandal and said, something tells me we've not reached the end of this scandal. It's likely far, far broader than imagined. When Franklin saw that tweet, he was very concerned and puzzled. At approximately 11:54 on Monday, March 25, FBI agents arrived at Franklin's house, and Franklin immediately called Avenatti, who told him, turn your phone completely off and don't talk to them. I hope Nike is not trying to mess you over. Avenatti then said, I'm going to go public, and he hung up before Franklin could respond. Franklin testified that at that point he understood Avenatti to be asking Nike to look into Carlton DeBose and Jamal James, negotiating a restitution settlement of $1 million for him, and discussing renewal of Nike's relationship. He had no idea about this retainer agreement. Auerbach said he viewed the tweet with utter shock and horror, deeming it completely the opposite of what Franklin's goals were. And then at 12:39 that day, Avenatti was arrested by FBI agents in the vicinity of Boies Schiller's Manhattan office. And of course, Boies Schiller is the law firm that represented Nike. So it went to trial. He was convicted. He argues one of his claims is the sufficiency of the evidence. In other words, there's not enough evidence to convict me of extortion because you didn't nail the wrongfulness element and you didn't nail the mens rea, or the guilty mental state element of bribery or the elements of honest services fraud. And so the court says, look, our standard of review on the sufficiency of the evidence claim, we have to sustain the jury's verdict if, crediting every inference that could be drawn in the government's favor and viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. That's not a hard hurdle to meet. Following that standard of review, they say the evidence was sufficient to support Avenatti's conviction. The wrongfulness element. So this is a fairly interesting discussion here. Let me see if I can keep it short and sweet. A threat to cause economic loss is not inherently wrongful. It only becomes wrongful when it's used to obtain property to which the person threatening is not entitled. To illustrate that, they talked about two different situations: a consumer's demand for compensation for injuries caused by a defective product, and a club's demand for members to pay outstanding dues. So, when the demands are supported by threats that bear a nexus to the claims of right, the injured purchaser's threat to lodge a complaint, for example, with the Consumer Protection Bureau, or the club's threat to publish a list of members who owe dues, there's no wrongfulness. But if the same demands are supported by threats lacking that nexus, for example, threats to disclose sexual indiscretions by the manufacturer's president, or the delinquent club members, then, even though the demands relate to the claim of right, the threats are wrongful and extortionate, because that is essentially blackmail, which is an element or a type of extortion. And then it says basically the evidence was sufficient to prove wrongfulness. Avenatti's retainer demand bore no nexus to Franklin's claim of right. In other words, Franklin had a claim that he had been mistreated. His demand for an investigation retainer bore no nexus to Franklin's claim. It was completely divorced from it, and in fact, it was self-serving. It was serving Avenatti's interest and not that of Franklin. There was no reasonable belief that the retainer demand served any of Franklin's goals, which is pretty much what I just said. There was no intent to conduct a bona fide investigation. It says Avenatti's nexus argument assumes his intent to conduct a bona fide internal investigation of Nike, one that he fairly valued at between $15 and $25 million. But the evidence not only did not compel that conclusion, it convincingly supported a contrary one, as we've already gone over. Specifically, evidence showed that in demanding $15 to $25 million, Avenatti provided Nike with only the briefest description of its scope and with nothing about the necessary work anticipated to conduct a proper investigation, the number of persons or the amount of time likely to be required, or how the work would be tracked and reported. Instead, his focus was on demanding the retainer. In short, everything that Avenatti argued failed, and they summarize that. They say the trial evidence was sufficient to support Avenatti's conviction for the two charged extortion counts because a reasonable jury could find therefrom that Avenatti's threat to injure Nike's reputation and financial position was wrongful in that the multi-million-dollar demand supported by the threat bore no nexus to any claim of right. And the trial evidence was sufficient to support Avenatti's conviction for honest services fraud because a reasonable jury could find that Avenatti solicited a bribe from Nike in the form of a quid pro quo, whereby Nike would pay Avenatti many millions of dollars in return for which Avenatti, in addition to forbearing on his extortion threat, would violate his fiduciary duty as an attorney by influencing his client to accept a settlement of potential claims without realizing he was receiving only a small fraction of the many millions of dollars that Nike would be paying Avenatti. That's what I have for you today. If you have to hire an attorney, be very judicious about who you hire and do some research. Talk to former clients. Almost any lawyer would be willing to give you the name of a former client who could tell you what their experience was like. And if an attorney can't give you the name of a former client, then you have to wonder about what kind of relationship he's had with his former clients. So that's my best advice in terms, it's not legal advice, it's just practical advice about how you go about hiring an attorney. If you have any questions, please leave them in the comments down below. like, share, subscribe, all those things we ask you to do. And if you have the opportunity today, go out of your way, do something nice for someone. Thanks for watching. Catch me down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.